Hello friends, welcome to UGC E-Pathshala. Today we will be discussing the segment on social legislation and crimes. I am Suman Dash Bhattamishra, Assistant Professor of Law at National Law University, Odisha. And as part of the social legislations and crime module, we will be discussing a chapter on an analysis of the Medical Termination of Pregnancy Act. Let me first introduce the topic to you so that we know what it is about. Abortion is a vital part of reproductive rights of women. However, only under certain conditions can abortions be legal. The need to frame laws to regulate abortions has been felt over a period of time. The primary reason for doing so is that if abortions are left unregulated, medical termination of pregnancies in which the fetus is female will continue uninhibitedly, leading to the death of girl children even before their birth. So, as a process of understanding the Act, let us go through the salient features of the Medical Termination of Pregnancy Act, which is passed in the year 1971. So, the first thing we need to know about the Act is what is the extent and application of the Act. The Medical Termination of Pregnancy Act was enacted in the year 1971. The legislative intent behind it was to make provisions for regulated termination of pregnancies by registered medical termination of pregnancies as well as for matters connected to pregnancies and incidental to it. The Act extends to the whole of India with the exception of Jammu and Kashmir. So, what are the qualifications for conducting abortion? Section 2 of the Act provides definitions of important terms which are relevant to the legislation. The term registered medical practitioner has been defined under clause D of the section. Now, according to the section, a registered medical practitioner should have the following qualifications. She or he should have recognized medical qualification under clause 2H of the Indian Medical Council Act. His or her name should have been entered in the state medical register. She or he should have experience or training in gynecology and obstetrics. So, what is a legitimate termination of pregnancy then? Now that we have known who can conduct or at what point of time a person would be said to be legal enough to conduct medical termination of pregnancies, we should know when a pregnancy termination is considered to be legitimate or legal. Section 3 of the Act lays down the conditions under which medical termination of pregnancy will be legitimate. Under the Act, termination of pregnancy will be legal if it is in accordance with the provisions of the Act, a registered medical practitioner terminates a pregnancy where the length of the pregnancy, and this factor is of paramount importance here, the length of the pregnancy should not exceed a period of 12 weeks. In case the length of the pregnancy exceeds the 12-week period but does not exceed a 20-week period, the pregnancy can be terminated if at least two, I would emphasize on the number 2 here, if at least 2 registered medical practitioners give their opinion in good faith that the pregnancy should be terminated for any of the following reasons. So, at this juncture it is important for us to understand that only when certain conditions are fulfilled can we say that it is legitimate to terminate a pregnancy, and even the registered medical practitioners can give their opinion under such circumstances only. Continuance of the pregnancy would involve a risk to the pregnant woman's life or grave injury to her physical or mental health, or if the child were to take birth, there is substantial risk that it would suffer from physical or mental abnormalities or deformities, as a consequence of which he or she may be severely handicapped. Now, apart from the above important factors, the section also makes the following very important provisions in relation to the provisions. Explanations 1 and 2 of the Act are the relevant provisions here. Firstly, there is presumption that if a pregnancy is caused as a result of rape, the anguish resulting from such pregnancy will be construed as a grave mental injury to the woman, and such abortions in these cases will be considered to be legitimate per se. Secondly, in cases of pregnancy resulting from the failure of any contraceptive device used by the woman or her husband for the purpose of family planning, the anguish caused as a consequence of such failure will also be presumed to cause grave injury to the mental health of the pregnant woman. So, at this juncture we need to analyze that under certain circumstances per se grave injury to the mental health of the woman is presumed to be there because the circumstances themselves are grave enough to justify them. The Act also specifically mentions that in order to determine what constitutes grave risk to physical or mental health of the pregnant woman, account will be taken of her actual or reasonably foreseeable environment. The pregnancy of a woman can never be terminated if she has not attained the minimum age of 18 years, that is the age of majority, or if she is lunatic, unless and until there is a clear and free consent of her guardian. It is to be noted that such consent must be in writing. Under all other circumstances, consent of the pregnant woman is vital and non-negotiable. Section 4 of the Act makes provisions for the place of termination of pregnancy. Any termination of pregnancy cannot be made at a place other than a hospital established or any other place maintained or approved by the government under the Act. The Act also states that under certain special circumstances, sections 3 and 4 of the MTP Act will not apply. Now, under section 5, the Act provides that provisions of this section in relation to the termination of pregnancy within a certain duration will not apply if in the opinion based on good faith of at least 2 registered medical practitioners, the termination of such pregnancy is absolutely necessary to save the life of the pregnant woman. Now, the termination of pregnancy by any person who is not qualified and is not a registered medical practitioner is punishable under the Indian Penal Code. So, it is important for us now to understand what are the powers of the central government to make rules which are effective for implementation of the Act. By notification in the official gazette, the central government can make rules for effective implementation of the Act. The purpose of such rules may be to make provisions for any or all of the following matters. Firstly, training and experience of registered medical practitioners. Such other matters that may be provided by rules under the MTP Act. Now, training of registered medical practitioners is a vital aspect and the central government has power to make rules pertaining to that. Drafted rules will have to then be put before both the houses of the parliament when they are in session, and if both the houses agree to make any modification, the rules may be modified. What is the power of the state government in relation to the MTP Act and what is its power to make regulations under the Act? The state government may make rules for regulating any of the following. Firstly, it may require any opinion to be certified by a registered medical practitioner within time as may be specified in the regulations. Secondly, the state government may require any registered medical practitioner to intimate the fact of such termination of pregnancy and such other information relating to the termination as may be specified in such regulations. Thirdly, it may prohibit the disclosure of such termination of pregnancy except to such persons and for such purposes as may be specified in the regulations. Fourthly, rules may be made to furnish information about termination of pregnancies to the Chief Medical Officer of the state. Apart from that, the Act also makes provisions for certain immunities under it. The Act provides under Section 8 that no suit for other legal proceeding shall be entertained against any registered medical practitioner for damages caused or having probability of being caused for actions done in good faith or intended to be done under this Act. This is a very vital provision, however. Now, the Medical Termination of Pregnancy Act has made certain very relevant provisions, but still it suffers from some shortcomings. The MTP Act suffers because it is several decades old and is not adequately equipped to meet the current challenges. It suffers from very serious drawbacks, as a consequence of which regulating backdoor and illegal abortions becomes extremely difficult. Now, some of the primary drawbacks of this legislation are as follows. Firstly, and most importantly, the biggest difficulty in the MTP Act is the fact that after the period of 20 weeks, a pregnant woman is not allowed to abort her child. This includes those cases in which congenital defects are discovered in the fetus after the period of 20 weeks. As a consequence of such provisions, parents may be forced to give birth to children despite the fact that such children will suffer from complex health hazards for the rest of their lives. This was the subject matter of the case filed by Harsh and Nikita Mehta along with Dr. Nikhil Dattar. Details of the case have been discussed subsequently in this module, and we will talk about the nitty-gritties of it a little later. Another major drawback of the MTP Act is the requirement that abortions may be made only by a certain category of medical practitioners. Given the social reality of India, the restricted scope of qualifications prescribed for doctors makes it very difficult to provide a larger variety of abortion service providers. Thirdly, accessing hospitals and other organizations recognized by the government may not always be possible for conducting an abortion, because it is not a smooth or easy task for Indian women, especially those from a rural background. This is also the reason behind backdoor abortions being a common practice in many parts of India. Fourthly, as a combination of all the above factors that we just discussed and the most obvious consequence of illegal abortions, instances of maternal mortality are very frequent. Fifthly, the Act lacks clarity on many issues related to medical termination of pregnancy. This is aggravated by the fact that many terms have not been defined under this Act. Due to a lack of proper definitions, there are major problems in controlling or forbidding the use of certain methods or procedures. So, it is necessary to define important terminologies like, for instance, abortion, methods of abortion, so on and so forth. So, keeping in view these many drawbacks and shortcomings of the 1971 MTP Act, several amendments have been proposed to the Medical Termination of Pregnancy Act. In the light of the above deficiencies in the MTP Act, the need for making major amendments has been felt over a period of time. With this objective, in 2014, a new bill was introduced to initiate major amendments in the MTP Act so that it can be made more effective and advanced in its implementation and scope. The bill proposes amendments in many sections of the MTP Act. a list of important amendments proposed in the bill is as follows. Firstly, a significant amendment has been proposed in relation to the qualifications of persons who can legally terminate a pregnancy. As per the 1971 law, a registered medical practitioner whose qualifications are recognized under the Indian Medical Council Act alone can make a legitimate abortion. However, according to the proposed bill, apart from the above medical practitioners, the following persons also can legally terminate a pregnancy. This proposed amendment is a significant one, so let's take note. A practitioner of Siddha Unani systems of medicine, a practitioner who is qualified in homeopathy, a nurse or auxiliary midwife who possesses adequate qualifications in general nursing or auxiliary midwifery. Now these are the persons who can conduct abortions apart from registered medical practitioners as per the bill, however. By increasing the ambit of persons who can legally terminate a pregnancy, two important objectives are accomplished. Firstly, there is greater access of Indian women to safe termination of pregnancy, and only qualified and recognized practitioners of traditional systems, nurses and midwives are provided as options, thus preventing people from accessing quacks. This also helps a lot in countering maternal mortality. Secondly, by enhancing access to nurses and midwives, there are wider ranges of options which are available for safe abortions. This goes a very long way in preventing backdoor abortions and contributes to the health of children as well as mothers. Secondly, a definition of medical termination of pregnancy has been provided in the Act as a procedure to terminate a pregnancy by using surgical or medical methods. Thirdly, the term registered medical practitioner is proposed to be replaced by registered medical health provider. This has been done keeping in view the fact that apart from medical practitioners, nurses, midwives and practitioners of traditional systems of medicine have been proposed to be recognized. Fourthly, under the proposed bill, the gestation period for the abortion has been increased to 24 weeks, unlike the maximum limit of 20 weeks in the 1971 Act. The proposed amendment provides that if in the opinion of the registered medical health provider, it is necessary to terminate the pregnancy as the fetus is at risk of developing serious abnormalities or there is major risk to the health of the child or the pregnant mother. Aside from other amendments, the above listed amendments are the most important ones which have been suggested in the new bill of 2014. An analysis of the new bill of 2014 is crucial for us at this juncture. So friends, let's get to know this bill. The bill introduced in 2014 has suggested vital changes to the MTP Act of 1971. The proposal is modern in its outlook and has a clear perception of the social problems relating to abortions in India. In India, it is not possible to completely overlook the reliance of people on traditional systems of medicine, and for every law to be operative, it must never lose sight of the context. So it is also important to understand that since ancient times, traditional knowledge and systems of medicine have provided for safe termination of pregnancies, and there is no harm in giving people the right to exercise a chosen method of medical termination of pregnancy. The only rider here is that persons conducting the termination of pregnancy are qualified in the disciplines of traditional knowledge. So instead of keeping out an entire domain of medical knowledge, The idea is to make the act an inclusive one. However, there has been severe criticism against the current proposal of amendment by doctors and medical practitioners across India. According to some, the proposal made in the 2014 bill is a retrograde step. The recognition of paramedics as persons qualified to conduct medical termination of pregnancy has been jeered at. But an appropriate stance in this connection should be based on an understanding that involvement of paramedics enhances access to proper health care and facilities. So, what is the question of viability in medical termination of pregnancy, and why are we coming to this issue right now? All the above discussion that we had leads us also to a grey area in the Medical Termination of Pregnancy Act. So, this is the issue of viability which we will be discussing now. A very important factor in matters relating to medical termination of pregnancy is the question of viability. The doctrine of viability refers to the point of time in the gestation period when the child acquires a distinct personality, and therefore taking a decision to end its life would be equivalent to an act of killing a complete human being. Different countries have different standards on the issue of viability. The case of Savita Halappanavar, a 31-year-old dentist who died in Ireland due to septic miscarriage, is a case worthy of discussion. In her case, Savita suffered a miscarriage as the state of Ireland declined her request for an abortion on the ground that it had completed 17 weeks and therefore had become viable. Despite the fact that there was grave risk to the life of the mother, Savita was not granted the right to abort, and finally she faced a traumatic death at a very young age due to a septic miscarriage. This case brings many important points for discussion. According to Irish law, at 17 weeks, the fetus becomes viable and acquires a distinct personality. Now, when it does so, aborting it is considered to be the equivalent of killing a human being. The same thing happens in India too, under the MTP Act of 1971, with just a different take on the issue of viability. Now, under the Act, the maximum period within which a fetus can be aborted has been set at 20 weeks. In Indian law, the fetus is said to become viable at 20 weeks, after which an abortion cannot be permitted legally. Now, medical termination of pregnancy involves substantial questions of law which are mingled also with questions of ethics. Striking the fine balance between ethics and pragmatism is a major challenge in the MTP Act. The case of Harsh and Nikita Mehta, who were declined an abortion by the Bombay High Court as the fetus was 26 weeks old when the request was made. In their case, the Dr. Nikhil Dattar found out that in the 24th week of pregnancy, the fetus had a congenital heart block, and it could be said with certainty that the child would have been born either handicapped or incapacitated. Under such circumstances, Nikita Mehta, the mother, applied to the court seeking permission for an abortion. A committee of doctors was constituted to examine the case of Nikita Mehta and Harsh Mehta, and an independent report was submitted by the JJ Hospital. Although the report submitted initially mentioned that the chances of the child being born defective were fair, later on the report was modified to suggest that the child being born defective and its chances of so were least. Arguments were also advanced by Nikita Mehta, stating that if the child was born with a congenital heart block, it would be required to attach a pacemaker in the heart of the child, which normally costs around 1 lakh rupees. And being a middle class family, they would not be able to afford the pacemaker every 5 years. Further, the trauma and difficulty of the child would be unbearable, not just for the child but also for the mother. Despite Nikita's arguments, which were very open in court, the court declined to permit the abortion. Harsh and Nikita Mehta had also requested the court to amend the MTP Act. However, the court said that it did not have the authority to legislate and the interpretation of the law was very clear in this regard. Nikita suffered a natural miscarriage in the 27th week of her pregnancy. However, the question raised in the case of Nikita Mehta is a very crucial one. Before taking any decision on this matter, it is apt to ask 3 important questions. The first and most important question is there any fixed universal standard as to the point of time at which the fetus becomes viable? Is it possible for a fetus to have independent existence at any point of time during the pregnancy? Should parents be given a right to choose whether or not they may keep the child once they discover the child will be born with congenital or complex defects? Only after a clear analysis of the 3 questions can we think of answering them. Answering the above questions is a very complex proposition. However, we need to weigh the rights of parents against the moral questions that abortions come with. If every parent is allowed to terminate a fetus because it would be born with birth defects, will that not be against the moral standards of procreation? Thus, a fine balance needs to be struck at this juncture, and in this context, the provisions of the MTP Bill of 2014 seem to be apt. Now it's time for us to conclude this segment. So in conclusion, I would like to say that the MTP Act has been in existence for several years now, but still it has not been successful in curbing sex-selective abortions. The Act needs serious revamping and restructuring to cater to modern needs. In this line, the suggestions in the 2014 Amendment Act need to be considered and deliberated on, and they do appear to be progressive in many terms. So let us summarize what we understood so far. The MTP Act 1971 has been enacted to regulate the termination of pregnancy under adequate supervision of registered medical practitioners. Although illegal abortions are an offence under certain conditions, abortion is legal. These conditions have been discussed in detail under the Act. A major loophole of the MTP Act is that it does not allow abortion after 20 weeks of pregnancy, even if there are congenital defects in the fetus. By limiting the qualifications for medical practitioners, a dearth has been created in relation to people who can conduct an abortion. In order to expand the scope of persons who can conduct abortion safely, the new bill has extended the rights to other qualified medical health providers. In Harsh and Nikita Mehta's case, the court has discussed the relevance of not giving permission to terminate the pregnancy after 20 weeks of period. The MTP Act needs to be amended seriously for ensuring that women have safe access to safe abortions and medical care. So finally, this is what we have understood about the Medical Termination of Pregnancy Act, which has critical ramifications on the criminological segment. With this, I would like to conclude this segment for you. See you again later. Thanks.